Mr. Chauvin is told that they can't even find the pulse of Mr. Floyd. You learn he's told that twice. They can't even find the pulse. You will be able to see for yourself what he does in response. You will see that he does not let up and that he does not get up. Even when Mr. Floyd does not even have a pulse, it continues on. It continues on, ladies and gentlemen, even after the ambulance arrives on the scene.
Welcome back to Court TV Live. I'm Michael Ayala. Prosecuting attorney Jerry Blackwell told the jury at the outset of this trial that Derek Chauvin not letting up and not getting up for 9 minutes and 29 seconds amounted to intent to end the life of George Floyd. Now, in our Court TV close-up, we are looking at the charges. There's 3 of them. Chauvin is facing second and third-degree murder charges and manslaughter. Now, to help you understand exactly what needs to be proven and how the state is going about proving it, we're going to take a look at those now. Now, remember, the defense, they don't have to prove anything. Now, bystanders and police expert witnesses have testified thus far that Chauvin seemed to exert too much force when his knee was on the neck of Floyd for that long. Let's go through each of the charges, and then we'll break them down. Under Minnesota law, second-degree murder is defined as an act that causes the death of a human being without intent to affect the death of any person while committing or attempting to commit a felony offense, and it carries a maximum sentence of 40 years. Now, I want to bring in my guest, Holly Davis. And Holly, the first hurdle that has to be overcome to get to the second-degree murder charge is the cause of death. And you have to prove that the knee on the neck was a substantial factor in the death of George Floyd, correct?
That's right. And that's why we focus so much in both the prosecution and the defense so far on whether or not it was the knee on the neck of George Floyd that caused the death. That meets the second-degree charge because the length of time is the assault, is the argument by the prosecution, or the defense's theory that it was actually drugs in the system of George Floyd and adrenaline that caused a cardiac arrest. That's why you're hearing so much questioning around the lack of oxygen and asphyxia and asphyxiation, because there are different interpretations of that lack of oxygen, whether or not you're on drugs or whether or not you're having someone's knee restrict your breath for 9 minutes and 29 seconds.
That's right. And for our viewers' edification, the fact that he took the drugs and they may have been a contributing factor in his death, as long as they find that the knee was the substantial factor, then that's enough. All right, let's move on now to our third-degree murder charge. According to Minnesota law, without intent to affect the death of any person, he causes the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind, those are key words, without regard for human life. Now, that carries a maximum of 25 years. Now, Holly, looking at the case so far being put on by the prosecution, where are you finding that they're going towards this charge? What evidence that you've seen suggests that he's guilty of this charge?
I think that all of the testimony by the police chief and the use of force experts is the differential here so that the prosecution can reach at the very least this catch-all third-degree murder charge. I think the important parts to focus on are we don't need to worry about the intent of the police officer in this situation. All the prosecution would need to do, they would say, is to show that this is an eminently dangerous act. We know that because it is satisfying the use of force definition. This is something that police officers use in very limited circumstances to get extreme compliance. So it's already eminently dangerous. The second prong of this charge is that it is causing this harm. It's a depraved state of mind, and it's sort of a recklessness standard. And I think that the length of time that Derek Chauvin's knee is on George Floyd's neck that exceeds the use of force policy, that exceeds the training he and every other Minneapolis Police Department officer received, therein lies the elements of that second prong, that this is something that went beyond what the use of force policy is. So I think that the prosecution is actually doing a great job of reaching this third-degree charge. I think the real tricky question is whether or not that second-degree murder charge is going to save the day. Of course, we've got a lot of trial to follow. We've got the defense case in chief as well. But so far, I think that the third-degree murder charge is definitely being addressed each day by each prosecution witness. And the past 2 days, in my opinion, are helpful to that. And if I could say one more thing about that, I actually think the bystanders are very important for that as well. They were the very beginning portion of this trial. The bystanders themselves were the ones that could observe that that use of force was killing George Floyd from their perspective. And so I think the prosecution did that to show that Derek Chauvin was charged with that reasonable person standard. If even a 9-year-old or a 61-year-old could see that George Floyd was dying, then Derek Chauvin should have seen that as well. And so the moment he was put on notice by the bystanders and even his fellow officers that this man was dying or unconscious or limp or lifeless or no longer resisting was something that I think the prosecution is focusing on to show that Derek Chauvin is not even meeting the reasonable person standard for that second-degree charge as well.
You know, I think it's absolutely important, you're right, those bystanders, because they provide a couple of things. You had the 9-year-old even testifying that he wouldn't get off the neck even after the paramedics arrived. They had to kind of ask him to take his knee off the neck. Yeah. That can be inferred intent. And then there was testimony from a bystander and from the chief that the angle that he was taking on the neck, he was actually digging into the neck and seemed to be putting his weight onto the neck. I think all those things, the ones you mentioned as well as that testimony, are all the things that is the sprinkling of intent that the prosecution mentioned. So great points that you're making there. Let's move on now to the manslaughter charge. Under Minnesota law, it's manslaughter if by the person's culpable negligence, whereby the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. And the maximum sentence there is 10 years. I think this one is you roll tape. Like if you just wanted a conviction on this charge, you just roll the tape and then you just send it to the jury. Really, I mean, I think the tape in and of itself proves this charge.
And that's why this is such a fascinating case, Michael. How many times do we actually get a video of the death? And that's why, you know, in this age of social media and this age of transparency, it's really important for the world to see this video, not because it's pleasant, it's terribly gruesome. But now we have actual objectively verifiable proof that we can juxtapose with what the prosecution and the defense is saying. If we have, like we did today, the lieutenant on the stand and Attorney Nelson says, but wouldn't a mad crowd really affect the officer's ability to, you know, take in the circumstances under this analysis? We roll tape and we see a 9-year-old with the word love on her shirt begging the officer to get off of the neck of a black man who's dying beneath the knee. And I think that the defense is going to ultimately have a hard time with that if the proper redirect is done by the prosecution in those moments.
No question about it. And I truly believe if we didn't have a video, nothing would have went viral. We might not have even had a prosecution in this case. All right, Holly Davis, I want to thank you so much for being with us. We're going to have to let you go now because the hour is coming up, but really appreciate it, and I know you'll come back and join us again. All right, up next, both the state and the defense put the finer points on how and when police officers can use force. We'll take you back into court for the wrap-up. Stay with us here on Court TV.